Okay, in this video I'm going to take a look at 9 things that I think you should know about redundancy. The type of redundancy I'm talking about is a non-collective redundancy. In other words, it's an individual redundancy. It may occur to you. You may be being made redundant in your job, or your position may be flagged up for redundancy or at risk of redundancy, or you may be an employer who needs to make a position redundant. So this video, I hope, will be of benefit. Okay, let's take a look. Firstly, you need to understand what a redundancy is. The definition of redundancy is set out in the Redundancy Payments Act 1967. There's 5 different aspects to it, or 5 possibilities, and each of them qualifies or constitutes a redundancy for the purpose of the legislation. So it's very, very important. The first one is the fact that the employer has ceased or intends to cease to carry on the business for the purposes of which the employee was employed. So that is an obvious redundancy situation, and one with which you're probably familiar. It's the standard understanding by people of what a redundancy is. There's 4 other types though. The fact that the requirements of the business for employees to carry out work of a particular kind in the place where you so employed have ceased or diminished, or expected to cease or diminish. This is a slight variation. The business is not closing up, but a particular section perhaps, or a particular type of work is no longer required. Third definition then is the fact that the employer has decided to carry on business with fewer or no employees. In other words, the employer has looked at the resources and decided to organise his affairs or her affairs in a different way, and the consequence of that is that fewer employees will be required. The fourth possibility is the employer has decided that the work for which the employee had been employed should henceforward be done in a different manner, for which the employee is not sufficiently qualified or trained. So the requirement for the work is something that the employee simply cannot fulfill, and doesn't have the capacity or capability, or isn't qualified or trained to do the particular work because the nature of the work has changed. It should be done or will be done in a different manner. That's another definition of redundancy. Remember, there are 5. And finally, the fact that the employer has decided that the work for which the employee had been employed should be done by a person who is also capable of doing other work. So this is a situation where a company may be downsizing a little bit and taking certain tasks off an individual, or taking all of the tasks off an individual, making the role redundant and giving those tasks to another individual who can also do other work. So we probably all know situations in the workplace where this has occurred as well. They're the 5 definitions of redundancy according to the legislation. And it's critical to understand and recognise them, because you may be looking to bring some sort of a claim to the Workplace Relations Commission on foot of redundancy, or you may be wishing to challenge your redundancy or the decision to make you redundant. But before you do that, you need to look at the definition and see whether you have a reasonable chance of succeeding or not. So the second thing you need to understand about redundancy is that there are basically 2 claims which arise from a redundancy situation. One, you, if you're an employee, may be claiming that it was a sham redundancy. In other words, it wasn't genuine. Again, refer to the 5 categories we've already taken a look at. Or you were unfairly selected for redundancy and someone else should have been chosen before you. These are the 2 causes of action, or 2 grounds for a redundancy based claim to the Workplace Relations Commission, and that is where it goes. So you're saying it's a sham redundancy, it wasn't genuine, and essentially it was an unfair dismissal. Or you're saying you're unfairly dismissed because you were unfairly selected for redundancy. If you can prove one or other of those things, you may have a valid, genuine claim that can succeed. However, if it's a genuine redundancy and if you've been fairly selected, then genuine redundancy is a lawful defence to a claim for unfair dismissal. In terms of redundancy payments, to qualify for a payment, you need at least 104 weeks of continuous service in the employment. That is 2 years. If you qualify, then you're entitled to 2 weeks' pay for each year of reckonable service and an extra week's normal pay, subject to a maximum of €600 per week. You are disentitled to a redundancy payment if you are dismissed for misconduct or if you refuse to accept alternative employment. So the alternative must have the same terms and conditions essentially as the previous role. So it must be a reasonable alternative. Number 5, a layoff or short time situation may give rise to the right to an employee serving a notice, essentially claiming redundancy. However, the employer can serve a counter notice if he believes he will be able to provide work within 4 weeks of receiving the notice from the employee. This work must last for at least 13 weeks. So this is a situation where there's layoff for short time and the employer genuinely believes it's only for a temporary period, then it's not a genuine redundancy. However, if it is for longer than a temporary period and the employee has served notice, well then ultimately he's able to claim redundancy if no work is forthcoming from the employer. Number 6, the notice of redundancy. The employee is entitled to at least 2 weeks' notice of the proposed dismissal. That's according to the legislation. However, that is only a statutory minimum. Your contract of employment may give you a greater notice period entitlement. So you need to look at your contract if you are an employee, and this is occurring. If the employer is unable to pay, there is a scheme run by the Department of Employment Affairs and Social Protection, the Insolvency Payment Scheme. Once certain criteria are met, you may be paid from this fund. Any disputes in relation to a redundancy or proposed redundancy must be referred to the Workplace Relations Commission. And the employer's conduct during redundancy is important. The employer essentially must act reasonably in arriving at the decision to terminate the employment. So he should give the employee the opportunity to put forward suggestions to save his job or to do alternative work, or suggest ways that the business could be run more efficiently to obviate the need for redundancy. The type of objective criteria also which the employer should use he needs to have objective criteria by which he chooses one employee over another. And he should really operate, or she should operate, some sort of a matrix situation, some sort of a decision-making matrix, which allows him to arrive at an objective and fair and reasonable decision based on fair and objective, reasonable criteria. You can't just use it as a method by which to get rid of somebody with whom the employer is unhappy. So that's the situation in relation to redundancy. I hope you find this video useful. There are 9 things that you need to know about redundancy in Ireland, non-collective redundancy. And if you find the video useful, you might give it a thumbs up down below, and you may be interested in subscribing to my YouTube channel.